Today we're talking about essential clauses in client contracts, and as a tech founder, what are the key things you need to be thinking about? Well, if you're a tech founder and you're drafting client contracts, first of all, you want to make sure that they are easy to understand and read. You don't want to be providing something that's really complicated, really complex, really long. It's going to be totally different from the sales journey that you've just had with a client. That's really important. You want it to almost be a continuation of your onboarding. So tone of voice, making sure things are really clear and transparent are really, really important. In terms of what the contract itself should actually include, it's very, very important that you are very specific on what the service delivery is. So what are you providing? When are you providing it? As the service provider, you want to make sure there's maybe a little bit of flexibility in there, just in case there's an issue with dates of delivery, if there's key dependencies, etc. You want to make sure you have some flexibility built in and you won't be in breach of contract if something is a day late, for example. Payment terms are obviously very, very important. You want to know when you're getting paid and how much you're getting paid, but you also want to give yourself some decent remedies if you're not paid on time. For instance, the ability to charge interest or stop providing the services if they're overdue on their invoices by a certain amount of time. There's lots of other things that you should have in a contract as well. A lot of them are legal boilerplate, things like warranties or force majeure clauses if there's an act of God and something goes wrong. But another key one that I wanted to talk about today is liability. As the service provider, it is key that you ensure you have a limitation of liability clause. This means that if something does go wrong under the contract, that the customer can only sue you up to that certain amount. I would originally go in at 12 months worth of fees. So if your fees are 10 grand for 12 months, that's the most you can be sued for. I would expect as you negotiate with more sophisticated clients that they will try to push that up, particularly for high risk areas, things like intellectual property breaches, data protection breaches, that kind of thing. And they might try to bring this up in line with your professional indemnity cover. That's okay. That's where a lawyer comes in. And it's important that you get that help and advice to make sure you're negotiating a really solid position for yourself. But with that in mind, those are the three key things that I would be saying right now to focus on. As a tech founder, your service scope and delivery within the contract, pricing and what happens if you're not paid on time, and also liability and making sure that you're not overly exposing yourself to risk there. If you'd like to discuss that with me or a member of the team, please just drop a comment below this video or send me a direct message. We'd be more than happy to have a quick chat with you about what it is that you might want to be thinking about and next steps that you might want to take to improve your client contracts going forward.